Good evening. Good evening, everyone, and welcome to this discussion on the global migration of the rarest of rare doctrine. Uh, on behalf of Project 39A and National Law University, Delhi, thanks for coming for today's discussion. Project 39A, as many of you might know, is a criminal justice program at National Law University, Delhi. Project 39A started its engagement with the criminal justice system through the death penalty, and currently our work encompasses many other facets of the criminal justice system in India, including forensics, mental health and criminal law, legal aid in the criminal justice system, and protections against torture. We also have an under trial legal aid program called the Fair Trial Fellowship that runs out of the central prisons in Pune and Nagpur. The Fair Trial Fellowship in these two offices has legal fellows and social work fellows, and that aspect of our work is dealing with only with under trial representation in the district prisons and the taluka courts there. And it interestingly positions us to try many of the things that we research and look into at the trial court level in the districts. But our death penalty work is primarily in the appellate courts and primarily in the Supreme Court and in the high courts. Over the years, we've represented and including the people that we've represented and continue to represent, we worked with about over 100 death row prisoners. It has resulted in 4 acquittals, 23 commutations so far, and we've lost 2 cases, one of which resulted in an execution. So that's the background with which we come in, and I head Project 39A along with teaching at NLU Delhi, and we have a fantastic panel today to discuss this idea of how the rarest of rare doctrine developed in Bachan Singh in 1980 has traveled to other parts of the world, and also looking at how it has traveled within the Indian Supreme Court over now almost 4 decades to reflect. And on that we have Siddhartha Dave, who's a senior advocate in the Supreme Court of India, and for Saul and Carolyn, that's the equivalent of a Queen's Counsel here. Siddhartha graduated from the National Law School in Bangalore in 1997 and has been practicing in the Supreme Court ever since. To my immediate left is Professor Carolyn Hoyle. Carolyn has been at the University of Oxford, the website tells me since 1991, right? And was the director of the Center for Criminology from 2012 to 2017. And I'm sure many of you have read her work and is considered among the world's leading criminologists, and has published extensive research on domestic violence, restorative justice, death penalty, policing, and very interestingly, her most recent work is on wrongful convictions, something that is of increasing importance and attention here, and the struggles of to examine the issue here. It would be a very interesting another interesting conversation on what are the terms of wrongful convictions here. On the death penalty front, she's currently working on foreign nationals at risk of capital punishment in Malaysia, and has also worked with us very closely on a very interesting study that we did on interviewing 60 former judges of the Supreme Court to understand their opinions on the death penalty and the criminal justice system. And I do hope you'll take a look at that work. Very, very interesting observations there. Saul Lehrfreund, to the far left, is the co-founder and the co-executive director of the Death Penalty Project in London. DPP has over 3 decades of experience representing death row prisoners in various parts of the world, from Southeast Asia to Africa and the Caribbean, and is so well positioned to really discuss how this doctrine that developed in Bachan Singh has traveled to all these different parts, how they have been altered, and in those alterations, showing what have been the deficiencies of the doctrine itself as developed in India. And Saul has extensive experience representing death row prisoners in criminal and constitutional proceedings across the world, and is truly an international authority on capital punishment and comparative international human rights law governing the issue. So thank you, three of you, for accepting our invitation to do this. And as we wrote on various social media handles, we've promised some very difficult and fundamental questions, both of how it has been developed here and it has migrated to other parts of the world. And then I think we're in a very interesting juncture in India where the legislature is showing increasing fondness for expanding the death penalty. But in the court, it's a slightly different picture. So that, and it'd be interesting to navigate through some of those contradictions, right? And I'll just take 5 minutes to set up the conversation, and then we'll have Saul talk about the migration of the doctrine and how it has been altered and what improvements have been made, and we can debate whether there are improvements or not, but we can debate that. And then that'll be followed by Siddhartha reflecting on what shape the rarest of rare doctrine has taken within the Supreme Court, and whether and to reflect primarily on how much of that difficulty with that experience emanates from the doctrine itself in Bachan Singh, and not as much as the changes it has gone through in subsequent judgments. And Carolyn will then reflect on what lessons these holds for us. All of these experiences from both India and other parts of the world holds for death penalty sentencing per se, and how we must, from a theoretical viewpoint, look at how to do death penalty sentencing. Right? So I think everyone in this room is aware of what Bachan Singh is, apart from upholding the constitutionality of the death penalty for Section 302 of the IPC. Bachan Singh lays down a sentencing framework. Very broadly, it says you have to identify aggravating factors and mitigating factors. You need to then assign appropriate weight to each of those, and then decide if the case is rarest of the rare, and then also decide if the alternate punishment of life imprisonment is unquestionably foreclosed. All of this, there might be various contestations of what I'm saying, and we can discuss that through the course of this discussion. But I think one of the main points that has led to very serious difficulty with death penalty sentencing in India is, of course, the inconsistent application of this doctrine. But if you interrogate why that inconsistency has arisen, one, it is inescapable that there are a lot of gaps within the doctrine itself as developed in Bachan Singh, right? In terms of how is weight to be assigned, and what are the relevant mitigating factors. And I think one of the major drawbacks of the judgment in Bachan Singh is to say, why are these mitigating factors? Why are these mitigating factors, and what weight should be assigned to them? Because we have seen in subsequent judgments, there are some judgments which say young age is a relevant mitigating factor. There are some other judgments which say young age is not a mitigating factor. Some would say, okay, we will look at poverty. Some would say we won't look at poverty. And there has been a complete lack of any doctrinal coherence in the jurisprudence in Bachan Singh and after Bachan Singh, right? In terms of saying, why are these factors relevant? Why should a sentencing court look at these mitigating factors? And because of the lack of the doctrinal coherence and the doctrinal foundation, judges have found it so easy on either side of that line, either while commuting or while confirming, to just invoke the ground and either dismiss it or use it to commute without any real reason as to how should we assign weight to each of these factors, right? And Supreme Court case law on this is rife with inconsistency, and I think fundamentally the inconsistency debate has been framed as if you have similar crimes, have they resulted in similar outcomes, right? And then a lot of discussion of inconsistency and arbitrariness is around that frame. If a 5-year child has been raped and murdered, can you show 20 cases on this side and can you show 20 cases on the other side? And I think that fundamentally misunderstands the inconsistency charge against the Indian Supreme Court. And I don't think that is the true nature of the inconsistency charge. And I want to make the argument that it is entirely conceivable, and I speak for myself only here, and I'm not in any way representing the position that the organization might hold on this, right? That if there were two people who were convicted for the rape and murder of a 5-year-old, both 25-year-olds, I would think within a death penalty framework, it is entirely possible that one gets death and one does not get death, right? And I say that because at the core of sentencing is individualized sentencing, that the sentencing framework has to look at who are these two individuals, who are A and B, what has been their experience, what is their mental health, what is their capability for reformation, right? And as long as you individualize justice, on the one hand, if there is a commitment within the sentencing framework to individualized sentencing, it should then be entirely possible that for the same crime, two individuals who are very differently located, the case could result in different outcomes. And therefore, the consistency that has been lacking is how do we collect sentencing information, right? In a system where the criminal justice system is under severe crisis, the legal aid system is broken, Bachan Singh has very little to say on how do you collect these mitigation information points. Who is to do it? What is the consequence for not collecting mitigation information? And Bachan Singh fails to make that connection between sentencing and the rule of law, right? And what is the connection between sentencing and fair trial rights, right? While there is there's far richer jurisprudence on fair trial rights and rights of the accused during the conviction stage, there is very little discussion in Bachan Singh or thereafter of what happens to fair trial rights when sentencing procedures go wrong, right? And therefore that doctrinal clarity is lacking. In terms of the reliance on crime, right? On this understanding of aggravating factors, what should the role be? Can you just look at aggravating factors? Not a very troubling performance from the Supreme Court for a sufficiently long period where they ruled on the fact that you could just look at crimes alone and the nature of the crime and sentence people to death on how terrible you thought the crime was. And of course, they recognize that error, and there has been some effort to offset the consequences of that. But I think one element that we could do with a lot more clarity in this weighing of aggravating and mitigating circumstances is how should we look at reformation? That's one question. And two, what is that meaning of that one line in Bachan Singh which says after you've given weight to aggravating and mitigating, you also have to show that the punishment of life imprisonment is unquestionably foreclosed. What does that mean? What obligation does that impose on a sentencing court? And you will see that on these two factors, on the question of reformation and on the question of what is the burden on a sentencing court to establish that the punishment of life imprisonment is unquestionably foreclosed, the comparative experience is very, very different from the Indian experience, right? And hopefully that'll come forth with a lot more clarity when Saul speaks, it'll be interesting to see that comparative trajectory, and then also listen to Siddhartha on that. So with those preliminary comments, I just want to stop here and invite Saul for his comments on this. Yeah.
Thank you, Anup. Hello, everybody. It's a very, very large audience. Something to do with mandatory attendance. We have problems with Anup, but we'll talk about that later. So it's a pleasure to be back here in India. India is very, very closely related. The jurisprudence from India is very closely related to the work that we do that's not in India. Our organisation, we've worked for more than 30 years in other Commonwealth jurisdictions. And what's interesting is when I started, so I started a year after Carolyn, so in 1992, I started the Death Penalty Project. And in every single country where we were, the death penalty was mandatory. So we didn't have to consider the whole question of sentencing. But we had the advantage of looking at how other countries who had discretion had developed their sentencing practices. And we were able to, and I'll explain the story, we were able to shape a sentencing framework that was much closer aligned to minimum requirements under international human rights law. And I'd also say the spirit of Bachan Singh, which is the presumption is in favour of life. And the presumption remains in favour of life throughout the entire sentencing process. And once you have that borne in mind, then you can develop a sentencing framework that gives justice to those basic tenets, those basic principles. But just to start off, I mean, I'm going off script straight away, so this may not work as planned. Anup's example, two identical cases, perfectly acceptable to have two different sentences. And I would say that's right. And the reason why that's right is it would be wrong if the only thing that mattered were the circumstances of the crime. But sentencing is not just about the crime. Sentencing, there are two sides to sentencing. So the first side is what was the crime, the gravity of the offence. And the second, and equally, or if not more important, the circumstances of the individual. So unless you have two replicants who are identical in all respects, then you'd have a problem. But in reality, that's never going to happen. So the judge has to, and a crucial component of sentencing in other parts of the Commonwealth has been to look at the individual. And once you do that, you have real individualized sentencing. So what I'm going to try and do very quickly is just a quick run through. It's going to be quite difficult to do this quickly, but I'll do my best, to look at comparative developments in other jurisdictions who have gone from mandatory to discretionary sentencing. And hopefully this will provide an insight into how the difficulties of capital sentencing have been confronted in those jurisdictions. But what we have not achieved, and nobody can achieve, is a system without arbitrariness. So I'll start with this and I'll end with this. Arbitrariness and subjectivity is always going to be prevalent in capital sentencing, whether it's the prosecution, the prosecutor, or the judge. That is an inevitability. And that is actually a reason why so many countries have abolished the death penalty, because of the inevitability of arbitrariness and the fact that there will always be an element of subjectivity. And it was one reason why we abolished the death penalty in the UK. It was anomalies, very similar cases, very different outcomes. And we realized there was just no way to develop a system that had no arbitrariness. And arbitrariness is unconstitutional and violates international human rights law. So once you accept that, then there's just simply no space for capital punishment. Okay, so let's see if this works. Okay, so very, very quickly, most people will know this. India hasn't had to confront, you have confronted in some judgments in recent years the mandatory death penalty, but it's clear now pretty much across the globe that it violates, the mandatory death penalty violates everything. It's inhuman, it's disproportionate, it's arbitrary, it violates the right to a fair trial, once you accept the sentencing as a crucial component of a fair trial. And in recent cases, courts have found that it violates also the separation of powers. A critical judicial function is to sentence. The world is moving very quickly away from the mandatory death penalty. Malaysia is the most recent country to vow to abolish mandatory sentencing. Trinidad, we have case pending on, that's the last Caribbean country that has a mandatory death penalty. We're about to challenge that. Sierra Leone, we also have a case. So there's virtually no mandatory death penalty left. But I'd say this, once you get to discretion, then these are the issues you face, okay? And what this slide really is saying is that judicial legitimacy and the rule of law requires that sentences imposed have to be appropriately justified, convincingly explained, common, and logical. And what I gather from what Anup said is this may well be lacking in Indian jurisprudence, those particular components. And it's the burdens and responsibilities that I'm going to focus on most today, on judges and other key players within the criminal justice system. And the questions that arise is, when is an offence eligible for a death sentence? What is the test? What does the test mean? What matters are relevant? And what special procedural steps are needed? And I think the last component, the special procedural steps, is where we've gone way ahead of India in other jurisdictions. Because the special procedural steps are critical to effective sentencing in capital cases. And I'd say without those procedural guarantees that have been developed by the judiciary in many jurisdictions, we'd have far more problems in capital sentencing. So the test itself, okay. So just very briefly, 3 approaches. So globally, we have a copy of this book that's been handed out. It's available on the website. That tells you about all the different sentencing systems that exist, okay? And the rarest of the rare test, and I'll call it that for now, that is the most common test in common law jurisdictions. The US has a different test, weighing aggravating and mitigating factors. There's no specific presumption in that test. And then in a few countries, you have a different presumption. It's the presumption of death and not life. But the rarest of rare test is the only test that's been developed by the courts, and we would say it's most compatible with international human rights standards. So this is the key, and this is, I suppose, the difference. The Caribbean African countries that have moved away from mandatory have developed a test. So the first part is the same, but it's a 2-stage test, not a 1-stage test. So the first stage of the test is, does the crime constitute the rarest of rare? So is it a particularly extreme, exceptional case that can fit into that category? If it isn't, you don't get to capital sentencing at all. The death penalty is off the agenda. But if you do get there, and I'll explain how you get there in a minute, and it's not automatic, and the prosecution have a big role to play, the second part of the test, which is distinct, is whether there's a reasonable prospect of reform and the object of punishment couldn't be achieved by any other sentence. So if you get past 1, you've still got to deal with 2. Okay? So even if an offence on the face of it seems death eligible, it's very probable that a lighter sentence may well be imposed. So that is it's a summary of how the test works. This is all throughout the Caribbean, Uganda, Malawi. They apply the test in this particular formulation. And the approach is stringent. And it's the imposition rather than the non-imposition that really does require special justification. And I think Carolyn will expand on it after, but the whole concept of no reasonable prospect of reform. This part of the test was very prevalent in South Africa before they abolished the death penalty. and there's quite a lot of jurisprudence emanating from South Africa pre-1995. And that's a very interesting aspect of the test. There's not really a judicial consideration. Some medical professionals say it's not really a medical concept either, so we're not really sure what it is. But it's a difficult question for a judge to answer, that's for sure. And I'll come on to that. It's critical to talk about. Okay, so the presumption of life. So as I said, the first stage, and I just add a few points here. I mean, there's a lot more to talk about, but I just want to stress a couple of things. So when you're looking at the first stage of the test, public opinion is irrelevant. It plays no role whatsoever in the determination of the exceptionality of the crime. Okay? Now that may well be different in India, but judges in the Caribbean, Africa do not take note of public opinion, and actually in the US they don't either. So there's Supreme Court dicta exactly on this point. The common law simply doesn't permit judges to subvert their function as arbiters of the law as to what they individually may perceive to be the requirements of public opinion. The second point is the offender's previous convictions. Again, totally irrelevant for the first stage of the test. Okay, whether the offence is the rarest of the rare is judged by the circumstances of that particular offence and that offence alone. Okay. The second test, the second part, no reasonable prospect of reform, has resulted in very, very few death sentences being imposed. Okay? It's very difficult to say that someone is beyond hope of reformation, or in other ways, incapable of reform. So it's making a determination today about future conduct, which really should be, I would say, an almost impossible task, if one was true to the language of that particular test. And I'll come on to another aspect of reformation, which is it's been mandated in a number of cases. The judge is simply not able to make an assessment on reformation without expert evidence. So a judge of his or her own volition can't decide that question. They need to be assisted by expert psychiatrists, psychologists, before they come to a conclusion on reformation. And if you don't have psychiatric evidence or psychological evidence, the judge simply, or the death sentence will be quashed by the higher courts. That is clear as well. So Anna mentioned aggravating and mitigating features. So a few points. Aggravating features are often defined in statutes. There's pretty much broad consensus as to what would constitute an aggravating feature. More than one victim, the offender inflicted deliberate suffering, the victim, the status of the victim, police officer, judicial officer, etc., offence committed in the course of a robbery. They're not that complicated. In some countries, the Bahamas is one country, they have a list of aggravating features. So unless you hit those aggravating features, you don't even get, you're not even, the death penalty is not an option. So only in very limited circumstances do you actually get to the rarest of the rare test. Now the difference with mitigating features is there's never been an attempt to prescribe a closed list. And it's a firmly established principle that any aspect of a defendant's record, circumstances of the offence, they all must be considered. And again, if you go into mitigating circumstances, there are the offence-based mitigating circumstances. So, for example, the presence of premeditation could be an aggravating feature, but conversely, the lack of premeditation or planning could provide important mitigation. And then offender-based circumstances. And I think Anup's point about a lack of real thinking about why a certain mitigating feature should count is lacking everywhere. So I was racking my brains to think, do they say why age matters? Or is it just a sentiment? And I think that on the whole, most mitigating features, and I'm going to leave one out, the most important one, which is mental health. That's different. And I'll come on to that as a separate category in a minute. But other mitigating features, there is an inconsistency in the weight to be attributed to those particular mitigating features. I mean, remorse would be an obvious one. There are some really obvious ones. If someone shows remorse, that's an incredibly powerful mitigating feature. But again, a lack of remorse doesn't necessarily point to an inability to reform. So none of this is clear-cut. And I think that the big difference is the guidelines that are being produced to guide the sentencing process. And this is what's made the real difference. And this is, if you have a discretionary system, you have the rarest of the rare tests, and you don't have guidelines, you are going to struggle. You're going to struggle to get consistency. And we would say that there's a duty on the state and on the senior judiciary to provide and to produce the necessary guidelines to limit arbitrariness in the sentencing process. And it's part of the price to be paid for having the death penalty, is the necessity of producing judicial guidelines. And they're not authoritative and they're never prescriptive, so they don't fetter the discretion of the judge. But on the other hand, a failure to follow the guidelines will almost inevitably lead to a death sentence being quashed. Depends which aspect of a guideline, but generally, in the Caribbean, failure to adhere to guidelines is fatal to a death sentence. So I think it'd just be helpful to run through, these are the classic guidelines. So the jury return a guilty verdict, and then the trial stops. It stops. And at that point, the prosecution have to give notice of whether they intend to seek the death penalty. That is the starting point, and to identify the grounds on which they are seeking the death penalty. Number two is you then always have a separate sentencing hearing. So the case is adjourned, and the judge will ask for information to be presented at that sentencing hearing. Psychiatric reports, assessments, background reports, a whole host of information is needed to determine, to meet the test that we've described before. Okay? Next point, there has to be funding available within the system to do this. That is implicit. The prosecution have a very strong duty of disclosure. Again, that is demanded in the jurisprudence. So medical records, for example, would be an obvious aspect, that there's a duty on the state to disclose someone's medical records. Critically, the burden of proving aggravating features is to the criminal standard beyond reasonable doubt, and that burden is on the prosecution. And the prosecution must also disprove, beyond reasonable doubt, the presence of mitigating factors relied on by the defendant. And the judge must provide full written reasons at the sentencing stage. So these guidelines, if you think about, do you have these guidelines? I presume the answer is no. And then you think, well, would this make a difference? And I think the answer must be invariably yes. To what extent, I don't know, but I can say that in the countries where we work, these guidelines have really made a difference between life and death. Now, mental disorder, I said I deal with it separately. I think, why is mental disorder different? And I think it's simply because at common law, the presence of mental disorder is a bar of itself to the imposition of the death sentence, and it clearly is under international human rights law. So irrespective of whether somebody can run a defense at trial based on mental disorder, at sentencing, we would say it's a total bar to the imposition of the death penalty. It's hugely problematic. The need for expert evidence it's a mandatory requirement in the Caribbean. Malawi too, oddly, a very poor country, but their judges expect to have psychiatric evidence or evidence from a mental health expert before they sentence. But it's a very neglected area, it's a very misunderstood area, even in these jurisdictions, and there are many pitfalls. So just very briefly, first of all, just a clear lack of knowledge and exposure to the issues within the legal profession. So how much do lawyers understand, judges understand about mental disorder? Causes, manifestations, impact, I'd say not very much. there's often a lot of suspicion around a defendant's motives when mental disorder is raised. And then the key problem is a lack of resources in terms of funding and personnel. But the bottom line is if you can't provide what's needed, then you can't sentence somebody to death. So it's a real minimum standards approach. And ultimately, the duty, I mentioned at the beginning about duties and responsibilities, the duty is on the state. Okay? So if the state wants to have the death penalty, the state has a duty in this regard. And the rationale for ensuring that there is medical evidence and mandatory requirement is, first of all, is the importance of mental disorder as a mitigating factor of itself, the first part of the test. But it's really the second part of the test where it matters on the question of reformation. And it was raised, there's a very famous case in the Privy Council called Lockhart, which I'd implore you to read. And the prosecution said, we don't need to produce psychiatric evidence in every case. And the Privy Council said, well, actually you do. And you may well have to produce psychological evidence as well. Because how the hell is a judge meant to tackle the question of reformation without it? It's almost impossible. So I'll scoot through that quite quickly, but there's a lot of jurisprudence around the area of sentencing and mental disorder. There's a very difficult question, which is the extent to which somebody is disordered or impaired. How ill do you have to be for it to count? And that's a very difficult question. But I'd say that we have diminished responsibility in the UK as a defence. I'd say someone that doesn't meet the test of diminished to have their conviction reduced, but is close, that would qualify. So you don't have to have classic mental illness like schizophrenia, psychosis to qualify. A moderately severe form of disorder will suffice. Mental impairment, intellectual disability is harder. There's no uniformity in understanding at what level, but generally, and it's done through IQ, which is not great. But generally, around the IQ level of 70, anyone below that would be disbarred from being sentenced to death. So there's a lot to talk about, but that's a very brief overview of what's gone on in other countries in the world when it comes to discretionary sentencing by importing the rarest of the rare formula. But I think I'd end up by just saying that, this is a cautionary point. We don't for 1 minute say that having a good sentencing process is the end of the problem at all. It's much better than a mandatory death penalty, because we worked in mandatory jurisdictions for a very long time, that's for sure. And it reduces the number of people facing a death sentence, undoubtedly. But even reforming the law to this extent does not remove arbitrariness in the process. It will limit it, but it will not remove it altogether. Subjectivity is inevitable. But pending abolition, which is the ultimate objective, we would say, and it's clearly the objective of international human rights law, judges need to apply the death penalty as consistently and as restrictively as possible with constitutional safeguards and international legal principles rather than without them. So I'll end on that note. Okay, thank you.
Thank you, Saul. If I may just invite Siddhartha to give his comments on his observation of how the Supreme Court has dealt with death sentence jurisprudence, and through that also reflect generally on how the Supreme Court is engaging with appellate criminal law in its years of practice. Siddhartha, please.
So just don't take any notes, please. This is not going to help you in your exams or anything. This has nothing to do with it. They are on two sides which are completely alien to the profession. None of this or all of it can be used, and I can tell you with almost 99.9% accuracy, it all depends upon the judges whom your case is before. You can have all the guidelines. I don't mean to sound cynical. I don't mean to sound or belittle the work the people are doing, but 99.9% depends on the judges. There are judges who will never, ever award death sentence. Ever. As a matter of fact, you can check the number of cases. They will commute it to life. And that's not because they don't believe in death sentence or they don't believe. It's just some very personal religious, it could be religious belief, it could be some other belief in India that prevents them from awarding death sentence. There are others who are somewhere midway. All right, in some cases, offenses against children, certain rape and murder of children sort of enrages them. They will uphold death sentence. But murder of 3 adults doesn't enrage them as much. They will not award death sentence. And then we come to another extreme, which is invariably death sentence will be awarded. And by death sentence will be awarded, I mean the case that has come from the lower courts deals with the case of where death sentence has been awarded. There's no question of any reversal. So these are the 3 broad kinds of judges that you have in our courts, and much of it is dependent on their personal beliefs. But when you're arguing a matter of death sentence in a court, it is of course very emotive. And there are 2 sides, which is the state pressing for that death should be imposed, and you as the defendant, having already been tried in 2 courts, you're at the final appellate stage, and on which I must commend the Supreme Court now on the procedural safeguards they have put in place even after Bachan Singh, in that a review petition has to be heard in open courts and not just by written submissions. We still emphasize on oral arguments, so at least 30 minutes of oral argument should be given. That is a very good move that has been done. And second is that there is, which is not procedural, which is there is a shift because of the rarest of rare doctrine, but it eats up into another aspect procedurally, of giving life sentence for a particular period of incarceration, which was not in existence in India, which we know ordinarily refer to as hybrid sentencing. Because in India you have either life or death. And life was that it would be for the entire life of the human being, but there was no fixed period of sentence, unlike America where you could be sentenced to 300 years or 500 years, which is absurd because nobody can live, but anyway, we didn't have. What we did have was that you could be sentenced to life, which meant that before 14 years of having served actual sentence, the state could not remit the rest of the sentence. So what the court did was, because it was reluctant to impose death sentence, and because that shows that the number of death sentences that were being imposed at the district or the sessions level, which traveled and were confirmed by the high courts, was increasing, but the courts did not, they wanted to strike a balance between not imposing death sentence and also not allowing an accused to go away with just having the possibility that he may be released after 14 years. So they sort of ate into the preserve of the state by saying that no, we will cap that period that exists, that we are sentencing, so it can be 20 years, 25 years, 30 years, and now it can be till the rest of ordinary course. So that is one way that the doctrine has actually traveled or migrated in India, is that instead of imposing death or life only, you start imposing a sentence which is, to the judge's conscience, would be sufficient to meet the enormity of the crime that has been committed, by saying that, all right, you will be not released, you will not be released 25 or 30 years, which is generally the average that they've been giving, of the person's life. Now all this is theoretical, because as I said, when we do matters where Anup and his team are involved, and very competent and good people, when they come and say death sentence has been imposed, what do? You see, death sentence, you have to understand the context in which the judgment arose, and just listen to it. When you have a left-leaning liberal court, you will find judgments, or a judge, you will find judges do not ordinarily give the sentence of death. When it shifts in a country or worldwide or whichever be to a slightly right-leaning jurisprudence, death sentences become more pronounced or are given more liberally, and which is why it is because for every crime that is committed, because of the public outcry, there is a shunning. I'm not a left-leaning person. This is not an advocacy on that part. I'm far from it, but I'm just analyzing the thought. That's why this imposition of death sentence in POCSO recently is all because of the kind of public outcry that is taking place. In the 70s and 80s, the Supreme Court was dominated by left-leaning liberal judges. By liberal, it meant that if it was an individual versus the state, the individual's rights were upheld. If it was business against the state in matters of taxation or nationalization, the business houses, they lost. So this entire jurisprudence of Bachan Singh, and more important than Bachan Singh in my opinion, was MeToo. MeToo has been sent out to the world on mandatory death sentence, that it's not constitutionally valid to have mandatory death sentence. Bachan Singh is slightly incongruous in my opinion. It lays down all these various factors, which as Saul said, and in his very nice presentation, it makes it totally and completely subjective. And as Anup said, for every case that you will have a death sentence imposed, you will have at least two on similar facts, if not the crime being the same, is what he meant, rape and murder of a child, or murder of 3 or 5 people of a family, you have a life sentence being given also. But when it did evolve, in 83 or 82, when the judgment did come, they were grappling with death sentence in a sense from a human rights point of view. The legislature also at that particular point in time, coincidentally, happened to be a slightly more left-leaning liberal legislature. So they came out in 73 with the amendment of special reasons. Now, it is not something that the Supreme Court itself evolved this rarest of rare doctrine by itself, that, oh, the legislature is saying one thing, but we will have a doctrine which sort of restricts what the legislature wants us to do. No. At that time, they were in tandem, and they did go about it by saying the legislature prescribed that if you want to give death, you give special reasons. The Supreme Court, in its wisdom, on the constitutional challenge to death sentence, somehow uses that since death sentence is not going to be imposed in so many cases or as many cases, that is the reason why we uphold its validity. That's why I say it's sort of incongruous in its nature. It's inherently contradictory. You can't have a imposition of death sentence, a challenge to death sentence being upheld on the ground that it's not so widely imposed. We are restricting it because of special reasons, rarest of rare, so therefore we uphold the death sentence. No, you uphold the death sentence on the constitutional principle. Be that as may. When MeToo comes, which is following, and one of the judges or 2 judges were common in it, it says no, mandatory death sentence is violative of Article 21. And for the simple reason it is violative is because it gives no discretion to the judge to impose any other sentence. And therefore we say that 21, I'm sorry if broadly, if I want to inform everyone else, it's our right to life and personal liberty. If we want to do that, it cannot be because there is no discretion that is vested with the judge. Now, it also takes why it is important is what Bachan Singh doesn't do is it takes the due process, which was up till then procedural, it takes it to a substantive due process. So therefore, when it strikes down Section 303 of the IPC, that is a substantive law being struck down, not a procedural law being struck down. So that could have been, had it come, in my opinion, a little earlier than Bachan Singh, had MeToo come, then maybe the doctrine that was evolved in Bachan Singh could have been used in MeToo, could have been used in Bachan Singh. But ultimately, as far as the working is concerned, when the death penalty, when death sentence cases do come up, there was a period of time from 2005 to about 15 where death sentence cases, as you all know, there is no right of appeal in death sentence. It still falls under the jurisdiction, what is known as special leave petitions, which is at the discretion of the Supreme Court whether it should issue notice or not issue notice. So they were being dismissed in limine, as in at the admission stage itself, the court, the Supreme Court, I'm speaking of the Supreme Court because still the High Court, of course, it's a matter of right. Supreme Court was dismissing those in limine. That means when the petition would come up for the first time and the counsel for the accused would stand up and say, this is a death sentence case, and say, but this thing, they would say, no, we see no reason to interfere, dismissed. One line, that's it, or maybe one word, dismissed. That was sort of having an impact till this judgment in Arif comes, where they say that, you see, this in limine dismissal and this, it cannot be, it has to be heard by, firstly, death sentence by 3 judges. Because normally Supreme Court sits in benches of 2, so it should be heard by 3 judges, which again does it, that which restricts the number of courts that it can go to. It only goes to, generally the senior judges are there sitting in a combination of 3. One, and then the other is this hearing in of the review, which is again by 3. So now in Supreme Court you have, so death sentence in India, surprisingly, is person imposing death sentence at the first stage is only a sessions judge. We don't have a jury trial, which is a finding on fact and finding on law. All what Saul said and laid out here about the rarest of rare doctrine are rarely found in judgments of the trial court. Rarely. All these are there in Bachan Singh's judgment. That is the law as far as in under our constitution. We don't need separate sentencing guidelines because this is the law. The courts are duty bound. It's law declared by Supreme Court and it's binding on all the courts. It's declared. What it's rarely adverted to, then it goes to 2 before the High Court. 2 confirm it. What is then left if you are having 3 at the last stage after the evidence has been churned, the evidence has been found, findings of facts have been recorded, for you to approach the Supreme Court and expect that the Supreme Court is then going to not award death sentence. It is a very, legally speaking, a very tall order. It's impossible to achieve at times, and therefore when we have matters in the courts, in Supreme Court, we decide on the basis, as in we as in lawyers and everything. The first question you ask, and there are some senior lawyers sitting here as well, you ask, who is it before? Unfortunately. That is the question. You want to argue it, you know that what the outcome would be. There are many judges who will say, we are not hearing on conviction, we'll just commute it to life, and it gets commuted to life. There are a lot of judges who will say, no, we'll hear the appeal, and if we find it that conviction, in this case, then sentence will ordinarily be death. That is how you're coming. So all the studies are good. The studies do, I'm sure they turn the public into having the opinion more towards the abolition of death sentence. But as far as the courts are concerned, it moves in a slightly different direction than all these. We will cite Bachan Singh, we will cite the following the judgments after that, we will cite all of them to the courts, but let me tell you, ultimately it will be on the subjective satisfaction of the judges who are doing it. So you may have one judge who may not like to give death sentence, he'll probably dissent on sentence, agree with the conviction. You may have 2 judges who agree with, have no qualms about awarding death sentence, they will uphold the death sentence. So that is where it is. I don't want to be cynical, I don't want to dissuade any of you from practicing criminal law or death penalty or these aspects, but yes, it's going to take a toll on you. You will, because there's nothing worse than having a person you've represented be given a confirmed death sentence by the court. Believe me, I was just 2 minutes more, I was having a chat with a colleague who practices income tax law. So he told me, you know, the difference between your practice and my practice is that yours is all personal. That when you come out of court, you have to tell the family that your person is going to be sentenced to death. When I come out of court, I just have to tell the company secretary, oh, you've been burdened with 55 crores of tax and you have to pay for it. I mean, it really doesn't matter to me. I said, yeah, and it made sense. And a tax lawyer was telling me that, and see the kind of impact it has on you, the kind of preparation it requires for a death sentence, which is not brilliant in the Supreme Court. Please be under no illusion about that. Matters are argued in the most unprepared, haphazard manner, without adverting to evidence, without having the evidence. Many of them with the Supreme Court Legal Aid Committee, again, they are not represented properly, and those people are. So death sentence, of course, there's a very strong reason for abolishing it, that it affects only the poor, it affects the minorities, it affects people who don't have proper legal representation in court, even up till the Supreme Court. And that's my take on whatever is being dealt. I'm sure this is not part of your course and all, but when you go out in the world, you will know that this is the practical aspect of it. Keep it in mind for those who do go into criminal law practice. This is what it's going to be. But I must say, this is all these. I'm going to use what Saul has laid out as these in the next death penalty matter, and there are plenty of them pending in Supreme Court. And if with Anup's team, we are going to use them. But let's see how helpful they are to us. We'll keep you informed about that. Thank you.
Thank you, Siddhartha, for giving everyone a very real sense of what our work involves on an everyday basis of grappling with just the reality of the courtroom, and it's so important, especially for the young students here, to realize that, of course, you have to go armed with the best of preparation, but you also have to be prepared for what you will face from a judge, right? So. It's in no way to say that it's a substitute for preparation, that the kind of unfortunate realism that Siddhartha was alluding to. But all that you can do as lawyers is to be prepared and try and keep pushing the law, which is what we do while working with lawyers like Siddhartha. And that is so important to know that court craft of, it's one thing to know all these arguments, and it's completely another ball game to know how to push it before a judge. Thank you so much. Carolyn, the very easy job of trying to make sense of all of this and sort of just tell us how to think through some of these difficult issues.
Okay, thank you. And before I start, I should say I want to wish you all the best of luck in your future career as tax lawyers. I'm sure you'll all be pursuing that with vigor from now on. So I don't want to take up too much time because there are plenty of people in this enormous audience. It's fantastic to see so many people. So just to pick up a few threads from the last just under an hour. I think what is clear is that with the decline of the mandatory death penalty around the world, it's opened this door really for consideration of this terrifically important issue about how to structure discretion. It's also clear to me, and to anyone who studies this subject, that establishing a doctrine for restrictive application of the death penalty for the most heinous crimes, as has happened, of course, with the rarest of the rare, which we've been talking about, is necessary, but it's in itself insufficient. So it's only half the job. Next must come the establishment of clear and rigorous sentencing guidelines to structure that discretion, to guide sentences, whether they pay any attention to them or not, they should at least be there. And I hear what you're saying about judge-centric sentencing because it's what we found in the public opinion study. So I'm not dismissing that for the moment, but in theory at least there should be rigorous and clear sentencing guidelines to help those people tasked with this terrifically difficult job. I think one of the points that Saul raised, and it's very important to the work they do here in the team at 39A, is to think about the responsibility of the state that retains the death penalty to provide the necessary resources to ensure a fair and properly informed sentencing assessment process. And part of this is the importance of collecting expert evidence, psychiatric evaluations in particular, in order to decide these difficult cases. But again, the gap between the theory and the practice here is very real, and it's important to consider the availability of psychiatric and other expert evidence in any jurisdiction. So in most countries that use the death penalty, there are insufficient resources to guarantee that defendants are both subject to themselves and that the courts receive appropriately thorough expert evidence in these cases, thorough and independent assessments. And of course, there might not be funds to commission this research prior to sentencing. And that's particularly so in African nations that retain the death penalty. A student of mine has recently done some research in Ghana and Sierra Leone, where there are many women on death row who were sentenced to death for killing violent husbands after years of domestic abuse. And in those cases, in a well-resourced jurisdiction, of course, they would have the battered woman syndrome defense presented to the court. In those cases, there weren't the psychiatric evaluations to do that. And so women remain on death row who really should not be there. And it's questionable indeed whether they should be in prison at all. And you only have to look at some of the jurisprudence in the US to know that even the richest of retentionist nations find this tricky. There are difficulties in how to assess risk if you're thinking about reform and whether people can be rehabilitated. And risk assessment tools have limited efficacy in these cases. They tend to be tools used comparing the individual to aggregate data, and I would say that those are beyond the scope of what judges should be considering in these important cases. Judges should also be considering, if they're thinking about reform, how to think about the treatability or the management of offenders with certain conditions like psychopathy, and not assuming that these conditions should rule out a life sentence, because people can be properly managed on life sentences, even with the most extreme disorders or mental health problems. And of course, common law, notwithstanding international law, but common law prohibits the execution of those who are at least moderately mentally disordered because of concerns about culpability when you think about the offence, but also concerns about their ability to assist their defence. And legal representation is never brilliant in most countries that have the death penalty, and so those people who can't assist the defence are particularly disadvantaged in these processes. I think the other thing that I think Saul touched on was the importance of a bifurcated trial with separate sentencing phase following the verdict, which you don't have here in India, but most countries that retain the death penalty have gone on along those lines. And indeed, you will know the very famous case in the US in 1972, Furman versus Georgia, which imposed a temporary moratorium on the death penalty there. When the new cases came through in 1976, following the Gregg versus Georgia case, states really couldn't get their death penalty statutes past the Supreme Court unless they had a bifurcated trial, and of course unless they also had abolished the mandatory death penalty. So these were considered the central elements for a fair death penalty system, and that is not me saying that the US system is fair. It is absolutely not, but at least these were the essential requirements. What's also been touched on in the last two presentations was the irrelevance of public opinion to sentencing, or what should be, in theory, the irrelevance, but what we know in practice is not actually irrelevant. Public opinion should play no role in engaging the seriousness of the offence or what the appropriate punishment is. This should be for all offences by and by, but it's particularly so when somebody is at risk of losing their lives. And it's particularly so in these cases, not just because of that risk, but because these cases that end up in a capital trial are heinous cases. They are disgusting. What people do to one another is vile. And most people in this room would look at these death penalty cases and be repulsed by them too. And that's important to remember that those feelings should not have a role in sentencing. It's fine for people to feel that. It's fine for the media to report on that and editorials to lead on that, but it's not fine for judges to then be influenced by the media reporting on that or by demonstrations in the public. And that's happened in recent years. Excuse me, in recent years in India around sexual crimes. So I think I think that's particularly problematic. And again, I think Saul mentioned the Furman versus Georgia case that I mentioned before. Justice Powell, in that case on the US Supreme Court, made it very clear. He said that however one might try to assess the amorphous ebb and flow of public opinion, and I think it is quite hard sometimes to assess just that, the assessment of public opinion, or popular opinion as he put it, is essentially a legislative, not a judicial function. I think it's very important to recall. And again, Saul mentioned the Constitutional Court in South Africa that abolished the death penalty in 1995, and that court also looked at the role of public opinion. And I quote from the judgment in that case, "This court cannot allow itself to be diverted from its duty to act as an independent arbiter of the Constitution by making choices on the basis that they will find favour with the public." So these serious judgments in these very, very heavyweight and influential cases both considered this. And of course, the same must be true for courts responsible for sentencing here. So in Bachan Singh, the court explicitly prohibited judges from attempting to determine the demands of public opinion, or what they call the collective conscience of society, as sentencing considerations in capital cases. Again, a quote from that judgment: "Judges should not take upon themselves the responsibility of becoming oracles or spokesmen of public opinion." And quite right. To do otherwise is, of course, to invite arbitrariness, to invite irrelevance into sentencing decisions, and to produce considerable differences in sentencing across cases. Unfortunately, as has just been said, what we find in practice is judge-centric sentencing. And so all of these factors and the lack of due process in the pre-trial and the pre-trial stages leave sentencers, rather than looking at coherent and clear and rigorous sentencing guidelines, grasping for amorphous notions of public opinion or their own internal prejudices or thoughts about what is appropriate. And that should never be the case. That just simply cannot be right. And I want to stop there because there's going to be, I think, a lot of questions from the audience.
So, yeah, I'm sure there are lots of questions, but I'm going to start with a question each to each of you, if that's all right. And so, if I can start with you, Carolyn, in terms of just when you talk of public opinion, and Saul spoke about how public opinion should not be taken into account, in Bachan Singh they say it, but then this whole question of object of punishment, the objective of punishment, in a lot of these trial court judgments that Nitika and Preeti have been looking at, that you see this very interesting narrative that we need to give the death penalty either to debtor as a measure of deterrence, and two, also that if we don't give the death penalty for an offense like the rape and murder of, I don't know, let's say a 2-year-old, the public's confidence in the law will stand destroyed, right? So that's not exactly public opinion in that sense. It's that really uncomfortable space between public opinion and objective of punishment. And yet, even in the objective of punishment, it is looking at a very generic understanding of deterrence, with no real burden on the judge to justify if deterrence is going to be achieved or not. The judge has no way to know that. But then how do you look at invocation of deterrence and the confidence of the public in the law? Do you easily characterize them as public opinion?
Well, first I think those two things need to be separated. Thank you. First, I think those two things need to be separated out. First is a question of sentencing rationales. So deterrence would be a sentencing rationale which is forward-looking, and then retribution one that's backward-looking, to put it at its crudest, rehabilitation, again, forward-looking. So I think judges need a clear sentencing rationale. Punishment without a sentencing rationale is simply inflicting pain with no rationale, and it's immoral. So if the sentencing rationale that judges are meant to be working towards when they impose sentences is deterrence, despite the fact that we don't have rigorous empirical evidence to say that deterrence works beyond a life sentence or a long sentence, then they have to articulate that deterrence is the rationale, and they have to say why, and they have to sentence accordingly. Similarly, if it's a retributive sentencing rationale, they have to simply say, look, the seriousness of the crime fits this particular sentence, so that's what we'll impose, and there is room for mitigation and aggravating factors in these rationales. So none of these, and really rehabilitation is much more individualized, but nonetheless it's a clear rationale. None of these should take into account what a general public feel. So I think in some regards those need separating out. I think what happens is that when the public feels that sentences are too lenient, and it's very rare that the public feel they're too harsh, when they feel they're too lenient, then you get a public outcry around certain offences, and again often violence against children, violence against women are the types of offences that get people agitated. And the public grasp onto what they know, and what they know is the end product, which is the sentence. And what I think the media have a great responsibility for to do, and I think we as academics do too, and activists maybe also, is to re-educate the public about the whole criminal process. Because when you actually pick apart what it is that people are anxious about in criminal justice, it's nearly always whether people are arrested and prosecuted and dealt with in some effective way. It's not usually the sentence. So the sentence becomes, not quite sure what the expression is, but it becomes the thing that people hang on to as the only thing they know because it's reported in the press. So I think confidence in criminal justice is important. I don't think it's irrelevant, but I think it's confidence that a criminal justice system can effectively identify the right offenders, can process them, can sentence them appropriately, and I think that gets translated as a thirst for punitiveness, when actually I think it's a thirst for efficacy and trust and reliability in the process. So I'm not saying that the public don't get agitated about these issues, they clearly do, and it must be very hard to be in the criminal justice system, especially a high-profile position like a judge, and to completely disregard that. But I think that they just need unpicking, and the public need more education on the pre-trial and trial processes and where there are flaws. So it's a long-winded answer, but that's kind of, I think, needs separating out.
Siddhartha, if I can just push you on the argument of we have to deal with judges who have very strong preferences, and it finds really strange ways of how it works out in court. And I think one of the big tragedies of what the Supreme Court has done with Bachan Singh is, if you look at what has happened to the framework in the high courts and the trial courts, it's just completely unrecognizable as to what has happened to it. But in that sense, to deal with that problem of judges doing this kind of realism, would you think that stronger procedural protections on how mitigation investigations are to be conducted, how this mitigation information is to be collected, to say that you can't convict the person in the morning and then say, now we'll have the sentencing hearing in the afternoon, so that the defense lawyer has no time to collect any information, saying what kind of mitigation information needs to come through without getting into whether you want to give death for child rape and murder or not. Do you think infusing the system with more procedural protections might help cut down some of that subjectivity that you were referring to?
I think we have enough procedural safeguards. The point is whether they are followed or not. You can legislate all you want, but ultimately, this bifurcated trial is what Carolyn was referring to. On sentencing, we also have, not as in a mini trial, but the judge cannot immediately sentence you after convicting. He'll pronounce his verdict, and then he'll hear you on sentence. And possibly, the lawyer who's been dealing with the accused knows what the mitigating circumstance, if he knows what Bachan Singh is in the first place in the lower courts, without any disrespect to the lawyer or the judge. The point of Bachan Singh is that it's too detailed in its aspects, I feel. It can go either way. It says you have these circumstances which are aggravating, then you have 5 others equally which are mitigating. it's a very complex judgment for a sessions judge to apply to a particular facts. I wish it was simpler. I wish it had less of these factors factored into it for its application. One of the reasons why it is so judge-centric is because the judge, while dealing with it, can't possibly, doesn't have the bandwidth to, I'm talking about the lower court level, to deal with it, and therefore the public outcry against a particular crime comes into it. He says, all right, yeah, this one I think deserves death. There are 5 which are mitigating, there are 5 which are aggravating. I think I'll go with the aggravating, and that's the end of the matter. And that's how it proceeds. So I don't know what procedural safeguards can you have, except better representation, legal aid especially, of better trained lawyers at the first level. Forget my appearing or anyone else appearing in the Supreme Court. It really doesn't matter. Because you see, the starting point is the conviction. If you can get you off on conviction, there's no question on sentence. Yeah. And invariably, you find all sorts of irrelevant evidence being led into. Public prosecutors' arguments are there on leading evidence which are barred by procedure. They are also read into it, ultimately. So you have to have proper legal representation, and that's it.
And the reason I asked that question, Siddhartha, was that in the Death Penalty India report that we published, we saw that lawyers barely ever meet their clients who end up on death row, and if you don't meet them, right, how are you going to collect this mitigation information that you need to present, right? And that's the reason why, that's got me thinking of, if you can demonstrate in an appellate court that the lawyer who represented you in trial barely ever met you, and therefore has not in any way given you adequate legal representation. But as you say, even those procedural safeguards, if a judge wants to get around it, they will get around it. And
what mitigating factors does he have to collect? Really, I would want him to meet the client for the conviction purposes rather than those mitigating factors which he will know. He meets the family every day, his wife, poor thing, or the children, and the entire family travels to some sessions court, they meet, he knows their family in and out, he doesn't have to meet the person to find out. In any case, in our jurisprudence, you are denied bail for one of the reasons in these heinous offenses. He is in jail, he's brought to court, that's the only time he probably meets his family as well. Otherwise they can't even travel to meet him. So out of all those mitigating factors, I have them, I don't want to bore everyone here about the mitigating. Sure. He's already aware of it, it's not as if he's not aware of it. Whether he understands it or not is a separate question.
And as we've seen, in some cases, the strongest mitigation strategy is to argue a very strong conviction case, right? And in terms of just plant that doubt, and as we've seen recently in terms of what we did. Sure. Saul, the question I had for you was on the strategies to look at reformation and the probability of reformation. And as you rightly said, our jurisprudence has not gone down the route of saying we need expert evidence or we need expert opinion on can somebody be possibly reformed. But one interesting thing that we've gone down on, and you flagged the issue that there could be concerns going down this expert route, and I'm sure there'll be some questions on that. One strategy that we have adopted is to look at jail conduct, prison conduct, right? To say that can we get prison officials, prison superintendents or jailers to certify that their conduct is good and this is what they've been doing in prison as an indicator of their capability to reform. So in that sense, I just want to take off from there and say, is there a non-expert way of looking at this in terms of saying, let's not get psychology or psychiatry into this because that has its own pitfalls maybe. What are your thoughts on a non-expert, or do you think it'll open up a lot more subjectivity from the judges?
Well, I haven't mentioned social welfare reports. So before you get to the stage of getting psychiatric medical information, expert reports, you nearly always get a prison welfare officer's report, like a social worker's report, which part of that will talk about the individual's conduct within prison. And invariably, if the person shows signs of rehabilitation, then that goes to the question of reformation. But that may not be enough. So somebody may not participate in education may be regarded as somebody that is a loner within the prison, is not compliant necessarily, but that of itself doesn't necessarily show that that person is incapable of reformation. So it doesn't complete the circle. I think the reality is, and I think this has been accepted by the judiciary in other countries that have adopted the rarest of the rare test, and it's pretty much conceded by the prosecution, is that this is very, very close to abolition. If you're true to the test, it's very hard to impose a death sentence. And that is what the courts are talking about, really. I mean, the rarest of the rare, beyond hope of reformation, you would think that there would be very few people where a death sentence would be appropriate. And that is really, I think, what's happened in Malawi. Malawi was so interesting because in Malawi, after they abolished the mandatory death penalty, they resentenced everybody who'd previously been on death row, and over 100 prisoners. And those prisoners could have been sentenced to death. That was an available option. And not one was sentenced to death under this particular framework when it was applied rigorously. So I think that's something else to bear in mind. I just wanted to come back to an answer to the first question, looking at the UK. In the UK, we want to have public confidence in the law and the judiciary and the criminal justice process, and we don't have the death penalty. So you don't have to have a death penalty to create confidence in the justice system. As Carolyn said, you need certainty and you need consistency. That creates confidence. I think the public, whatever the most severe penalty is, the public will demand the most severe penalty. So, and it works down if you look at other different punishment systems. So I don't think that it's acceptable to a judge to sentence to death to say that of itself creates confidence from the public. So in very short summary, there are other different ways to collect evidence, but I think mitigation comes from many different sources, but because you don't have a particular mitigating feature doesn't rule out other mitigating features.
Right? So we can open the floor to questions. Simple rules, keep it short, to the point, and just ask a question generally to the panel, and whoever wants to answer will pick that up. So yeah, and if you can just give us your name when you ask the question. Yeah, we'll take 3 questions at a time, and then yeah.
Okay, so my name is Ashwati. I'm a criminal law student. I just completed my master's in criminal law from Indian Law Institute, Delhi. So, sir, my question is specifically with regard to the class of offences against the state, specifically in respect of terrorist offences, where even the Law Commission once recommended that death penalty could be abolished in other cases but should be retained in offences against the state and terrorist offences. But sir, also to think in terms of, like you said, public opinion, and also even in terms of public confidence, doesn't retention of death penalty specifically in terrorist offences stand all the more problematic, because the public outcry is much more intense when it comes to terrorist offences? So how does it reflect on the retention of death penalty when we talk specifically about that?
My name is Shreya. So my question is that when a heinous crime is committed by a woman, do you still believe that there is a gendered narrative revolving around the trope of a woman being a provider and a caregiver, therein leading to certain extreme reactions of either considering her the personification of evil and therein being a complete abhorrence to womanhood itself, or therein otherwise the diametric opposite being that she's considered a victim of her circumstances, and how this would play into whether the crime itself would fall into a rarest of rare situation? I think the relevance of my question is only based on the submission that if a judge is the one who's going to decide whether to grant death penalty and so on, the judge would also be rooted in social mores. And these tropes come from social mores. I think this is more advocated by Roger Cotterell, but sociological approaches to law are the only real way to understand law.
Good evening, everyone. My name is Waleed. I'm from National Law University, Delhi. So my question is particularly to Mr. Siddhartha. Sir, in the light of what you have spoken about irrelevance of public opinion and the unfortunate realism that has crept in into the Indian courts, so my question is, given how the recent death sentences have been executed in India, and the public vigor about the legislation specifying death penalty, how difficult does it become for the accused to seek legal representation in such circumstances where the public opinion against the accused is such that it becomes even difficult for the advocates to represent them in the courts? Thank you.
Thanks. Saul, do you want to take the terrorism question?
Yeah. Okay, so we're aware of the odd bit of the Law Commission's findings without any justification as to why the death penalty is inappropriate in India except for terrorism offences. Sure, I mean, public outcry, the more heinous the crime, the more extreme, the more public reaction there's going to be. But that of itself shouldn't determine whether or not we have the death penalty. I mean, I can only just talk by reference to the UK. We have had, over times, terrorist offences. In more recent times, we've had terrorist offences. And interestingly, there's been very little outcry for either the reintroduction of the death penalty generally or in individual cases. So once it's not part of somebody's sort of normative values, that it's just not there, it doesn't exist, and people just don't call for it. And the other very interesting example is Norway, the Breivik case. Again, I think it was public opinion, I think there were 12% called for capital punishment in that particular case. So there are different ways to gauge public opinion, but I really feel that, or public outcry, just shouldn't determine the issue. And just going back to the Law Commission's report, everything it said that was wrong with the death penalty in India applies across the board, whether it's a crime of homicide or a crime of terrorism. And actually maybe the problems become more acute in terrorist offences in terms of problems in the earlier stages of the criminal justice process in terms of the collection of evidence and the treatment of suspects. So I think the more extreme cases, one becomes even more concerned in terms of due process and sentencing principles.
Would I have my history correct to think that the UK Parliament did away with the death penalty during the conflict in Northern Ireland?
No, we didn't. No. Before, 65.
65.
Yeah.
Well, there had been conflict in Northern Ireland,
There
it
had.
hadn't spilled onto the mainland.
Yeah.
That's the point.
Yeah.
Right.
Yes, there was a policing issue around that conflict, but it hadn't quite affected us.
But I mean, I think the conflict in Ireland is important because the most egregious terrorist offences that were tried in the UK courts, that if we'd have had the death penalty would certainly have resulted in executions. They were our grossest miscarriages of justice.
Yeah.
And innocent people were convicted. So that really put an end forever, I think, to calls to reintroduce the death penalty.
And also that a country like Israel doesn't use the death penalty, but whether we want to do what the Israelis do is a different question. But anyway, we'll leave that. So Carolyn, you will take the question on heinous offences by women and how the law and the courts look at that.
I will, yes. Don't you just hate it when people don't turn off their mobile phones? Sorry about that. Yes, I will answer that. Just to add to Saul's response to the previous question, if any of you haven't read the Law Commission report, it's worth reading because when I first read it, I was astounded because the whole report reads like it's going to end up with total abolition. And then you get this final section. And you think, oh, did I completely reread that? So read it from the, I mean, you know the answer now, it's not going to be a surprise, but read it from the beginning, you'll see the whole thing looks like it's going for abolition, and it's added on, so there's no integrity to the message of that story, I think, is what I'm saying. So Shreya's question, yes, sorry. That's a really good question, a really interesting issue. It's particularly interesting in jurisdictions in Southeast Asia where, hope I'm not going to insult anybody here, but patriarchy is alive and well, as it is in many places, and gender plays out in a certain way, and age plays out, and those two things intersect. Whether we like it or not, that's how it is. And so when you get a system which has judge-centric sentencing, and I think both the experience of working in the court here that we've heard, and also the research that Anup and his team have done on this, we know that that is the case here. So you're right, there are these tropes, social warriors that come out in sentencing, or come out in society anyway, our response to women as either doubly deviant or in some way victims of circumstances as if they don't have agency. I think these are terrifically important issues. They're playing out very interestingly in the UK right at the moment. A colleague of mine, Shona Minson, is doing a lot of work to try to get judges to consider seriously mothers when they are sentencing, the status of mothers as primary caregivers and the relationship between mothers and children. And this is a very interesting thing for me, because I would like fewer people in prison all around the world. Certainly in the UK, I would like to see fewer people in prison. We've had a gradually expanding prison population for decades now. And so the idea of excluding mothers from prison in particular, and finding alternatives to prison for sentencing, bodes well with me. But it does raise tricky issues about gender and about what sentences are thinking when they respond to crimes. And we've talked a lot this evening about arbitrariness in sentencing and irrelevant sentencing decisions. And so I think it's very problematic. Now, there are some cases, I mentioned one before, which is where women have suffered from extreme violence from a partner, or maybe from a son, or a parent, or a parent-in-law, where they have strong mitigating factors, but as Anup was talking about before, you can parcel that up as strong mitigating factors and keep certain sentences off the table in those cases without making it about presumptions around gender and agency, because to make it about that leads us to a situation where women are assumed not to have agency in any of their actions if they're assumed not to have it in their actions which go beyond what we think is acceptable behaviour. So I think I don't have a clear answer to this, rather that I just think it's a very interesting question, and I think I'd like to see more research on this, because if you look back to the work done by people like Carol Smart, I don't know whether you've looked at her work, way back, I studied her stuff when I was first around, back in the whatever decade that was. But there's not been a lot of recent research on this issue, so we're still stuck with a literature that's slightly outdated, I think, or at least I'm not aware in the UK particularly, or in the US on these issues. So if people are thinking about a PhD topic or a postdoctoral topic, I think this is a really important issue that you've raised, and particularly when we recognise it in the context of judge-centric sentencing. So thank you for raising that.
So Siddhartha, I think Waleed's question, if I got that right, was about very often we read that local bar associations or lawyers' unions either decide that nobody from there will represent a certain accused, be it for a terror offense or a sexual offense. What then? And none of that has to do with the kind of judge-centric subjectivity. What do you think we can, as a practitioner of the law, I mean, it surely is deeply concerning. What can we do about it?
Well, it really depends upon your personal ethics. As a lawyer, according to me, and this is your ethics, if a client wants to engage your services and is willing to pay for it, you have no business in deciding whether you should take up or not take up or judging that cause. It is your first duty is to take up that cause and argue for the client who's engaged you. You can tell the client that, look, I don't believe in whatever, not that you're guilty or something, but generally, I don't believe in the cause or whatever, but I am still doing it because it is my ethics and they demand. the question is particularly relevant to the other question, because in terrorism, the country, I mean, the people, the opinions are really, really strong. Some people, and people who have, in courts, even lawyers, think that due process should not be followed, and that people should be hung without even a trial, because they have the entire aspect of allegation goes. It's already proved. It's proved in the media. It's proved by the state, in everywhere except for the courts. So if you have, as a lawyer, if you are not willing to take up the most fundamental of all criminal jurisprudence, that the right to be presume that the person is innocent until proven guilty, and you're not willing to take that up, then I think you should just hang up your gown and just go home, probably become a teacher somewhere, practice something, so it's not worth it. It's really not worth it, and it's a clear violation of the lawyers, their oath. And so none of you, please, whenever you practice, believe in this, tell it to as many friends as you can, practice, be true to your oath, to your ethics. Practice law in the sense as a professional, not as a citizen or as a member of some party or as something else. You are a lawyer first, and that's of some eminence in the professional world. There is a reason, and I'm sorry, it will be in Hindi, that there are only two professionals in Hindi, and I'm sorry I don't want to impose Hindi on this thing, given the recent trend. Only two professionals who they call Sahab at the end. One is Dr. Sahab, other is Vakil Sahab. That is the value people used to have for lawyers. Don't degrade it by saying, I don't want to appear for so-and-so, or so-and-so is this, or something like that. It's against my belief. Give it your best, and that's what you're supposed to do.
You know that horrible cliche about teachers, right? That, those who can, those who can do, those who can't. Well, we teach. But anyway, no, I think it's a very important issue that just has very serious fair trial implications and rule of law implications. It's so rampant and so increasingly seen in the country that for certain kinds of offenses, bar associations just come out and not just refuse to represent, but also physically intimidate lawyers who want to take up those cases and argue those cases. So what that means for the right to fair trial and quality legal representation are all still issues to be addressed in our jurisprudence. Anyway, I think we have time for maybe 2 more questions. Yeah.
I'm Tripti, I'm with the Lawyers Collective. You seem to have conflated the idea of most serious crime and rarest of rare case. And I think there is an element of commonality, but it also appears that most serious crime from the ICCPR is more an injunction to parliaments, to the legislature, to be cautious and not to expand capital crimes, whereas rarest of rare is more an injunction to the court, to the judges, to apply certain principles while sentencing a person. But I also want to bring another facet, which is that the reality today across the world and in India is that there are perhaps more people getting sentenced to death, but less being executed. So would you then credit that to the rarest of rare, or fault that to the most serious crime which is not being followed?
Yeah.
My name is Shashank Shekhar. I'm doing my law from Jamia Millia Islamia. I'm the 3rd year, sir. I have 2 questions. One is about a case which has been decided in 2015 of Yaqub Main in per se. I want to ask if in that particular case, the Supreme Court have not applied the test of rarest of the rare in its true sense. And in a way, they have very categorically said in the judgment that it is to satisfy the public conscience, we are giving up this judgment. And even the Arif, the judgment of Arif, where the guidelines has been said ki how the execution will take place, was also not been very much implemented. My question is about if a particular court, the apex court of the country, is not applying the rarest of the rare and is more inclining its judgment on the public opinion, what is the way forward? Like, what is the way forward? And second question is about, we have come, the government is coming up with the new legislation where they are making stringent laws, like for the rape with a girl who is less than 12 years, the new legislation comes through ordinance, and that penalty has been there. What I understand ki the intention of the legislature was to deter the public at large. Does this, but we see, does this really deters the public at large? Like the intention is satisfied by the, does the legislature is really understanding the concept of rarest of rare? I mean,
you want to take the question on the difference between the most serious crimes and the rarest of rare?
Not really. No, okay, great question. Okay, I mean, the starting point on this is if you look at the jurisprudence of the Human Rights Committee under the ICCPR on the mandatory death penalty, the rationale of the Human Rights Committee to say that the mandatory death penalty violates the covenant is because the mandatory death penalty violates the most serious crimes principle. So that's how you get rid of mandatory under the ICCPR. They haven't said that it's cruel, they say it's arbitrary. So it's a violation of Article 6.2 and Article 6.1. So it's a question of arbitrariness, but also because it doesn't fit in with the concept of the most serious crimes. In the most recent general comment of the UN Human Rights Committee, which was last year, General Comment 36 on the right to life, they then go on and they explain quite clearly about the need for individualized sentencing and the need for the courts to look at the circumstances of the individual, not only the offence and the offender. So they don't prescribe the rarest of the rare. They don't say that is the only approach that you can take, but it's very close. So they definitely don't accept an extenuating circumstances approach that we see in Botswana and a few other countries. So I think they're very close to saying that this is the right approach where the presumption is in favour of life and the death penalty is exceptional. And I think the concept of exceptionality fits into the current thinking of the Human Rights Committee and the restrictive nature of the death penalty under the ICCPR. So I think the two concepts have started quite far apart, because originally most serious crimes were saying you can't have the death penalty for drug-related offences or non-violent crimes. But it seems to be that the most recent interpretation, the principles are coming very close and almost conflated. But I'd say that the other point about the way the rarest of the rare has developed in other parts of the world, especially around mental disorder, aspects of the tests take on and apply international minimum standards in how the rarest of the rare plays out. For example, mental disorder being such a strong mitigating factor that it leads to the non-application of the death penalty in virtually every single case. That accords with ICCPR jurisprudence. So I think that they are different concepts, but they're coming more and more conflated because international law is moving towards the abolition of the death penalty. Okay, so again, at the moment, the death penalty is lawful in very limited circumstances under human rights law, but those circumstances are becoming more and more restricted. So sentencing is one of the ways that the death penalty can be restricted, which accords with international principles. So that's a type of answer to a very good question.
Yeah. So, Tripti, in response to the issue that you raised on more people are about difference between people being sentenced to death and the number of executions being carried out, I'd say interesting difference in trends between what's happening in the trial courts and what's happening, let's say, in the Supreme Court. Like last year, we had the trial courts imposing the highest number of death sentences in about 20 years, if you look at just trial court imposition of death sentences. In the Supreme Court, I mean, unfortunately, I come very close to agreeing with Siddhartha on that the cases are that, you know, it's so judge-centric that I wonder if you put any case before them, the kind of judges that have commuted would commute pretty much any case you put before them. And in that sense, I'm wondering if there is an institutional story there. I'm skeptical that there is an institutional story. I think there is a individual judge's story to be told. I'm not so sure that that we have not seen executions in India, let's say in Shatrughan Chauhan, in some of the cases of there where Lawyers Collective was also involved, that it went before a certain bench. There were 14 people at the very verge of execution, right? If it were not for that judgment, you would see 14 executions because the president changed, right? And so in that sense, I'm not too convinced there's a institutional move towards commuting death sentence in the Supreme Court institutionally. Judge-wise, maybe it really depends. So I would leave it with that kind of vague answer. But certainly the worry that Siddhartha said in terms of this whole idea of life imprisonment without the possibility of release, I think we need to be very careful to not consider it a victory if we are getting those kinds of sentences instead of the death penalty. But there are worrying trends there, I would say. Yeah.
Tripti, for another reason, that this bias, or not bias, this personal preference exists not only in Supreme Court but in presidents as well. So when mercy petitions are sent or were sent, so you had K.R. Narayanan, you had Abdul Kalam, you had the judge, Pratibha Patil. They didn't deal with mercy petitions at all, which resulted in delay, which then got commuted by Supreme Court. So that's one of the reasons why, even though they were confirmed by the Supreme Court, the delay in deciding of the mercy petition gave an avenue or opened an avenue for them to have it commuted to life by Supreme Court. So that's the other. So that sort of personal prejudice, bias, opinion, whatever you may like to call it, ethics, does result in, even at the highest level of the constitutional functionaries. And coming to the case of Yaqub Memon, that's a very interesting case. And if I was answering it, I'm sorry, I just carried on to say, because it's a decision in India. It's peculiar, and not that I've just read it, it happened in 2015, but what I took away from it, and when you go home, you just read it, death sentence is given for abetting the offense, right? It's not that he was the perpetrator of the crime, it was for abetting. It wasn't so much, of course, it was a terrorist offense, or whether death sentence at all should have been awarded for abetting an offense where you're not the actual perpetrator. That is the real takeaway, and therefore I think the Supreme Court did not intentionally apply the guidelines of Bachan Singh and said that, look, this is a heinous crime, crime against state, we are not touching it, and therefore the death sentence, that is. But whether it was pointed out or not, whether this was abetted, it was only for abetment, is something you have to look at the judgment, whether the council actually made that point or not. When I read it, I thought that this was only abetment.
Miss Rebecca Jacob was the lawyer.
No, I think Jaspal Singh appeared for Yaqub Memon at the time of review. If my memory serves me correct.
Judgment which I read, so there was a...
Which was presided by the Justice Anil Dave presided over that bench. It was argued by Jaspal Singh. He was the lawyer for Yaqub Memon. I mean, I'm telling you offhand because I don't remember it. So this
when
thing.
we are talking in terms of death penalty, which is one of the worst case of punishment which we are...
Can we not have follow-up questions? Is this all right? Okay. Right? Otherwise, we just endlessly have the conversation. Right? I think in terms of responding to the question, one of the most worrying features of all, if you look at the executions in the past, if you look at the executions of Dhananjay Chatterjee or Afzal Guru or Kasab or Yaqub Memon, all invocations of all three-judge benches invoking an idea that is expressly prohibited by 5 judges by the majority in Bachan Singh, that you will not use public opinion or collective conscience, and yet you see that all these judgments invoking, and for me that is an institutional worry, right? The judges are willing, irrespective of what their individual predilections might be, that just as a certain kind of discipline of adjudication, to ignore precedent, that must worry us, right? Irrespective of whether, when you start giving effect to your individual predilections in contradiction to precedents set by a larger bench, that that moves beyond just realism. That's just something else, right? Whatever else you might call it to be. Carolyn, do you want to take the question on child sexual offences, which is where we are seeing great amount of action on death penalty and harsher punishments, non-homicidal offences now for child rape by amending both our general penal code and the special law on child sexual offences. Would you say that the harsher punishment conversation is just the same whether it is child sexual offences or anything else, that deterrence is, harsher punishments are not going to deter?
Well, two slightly separate points. The first is that it's slightly strange to see this movement to expand the death penalty given the sort of progressive restriction around the world and in India. I mean, the fact that you've got fewer and fewer death sentences, almost no executions, and then you have public outcry about particular types of offences and then an expansionist approach. So it's unusual, and I think it goes back to the point I was making before about certain types of offences do stimulate enormous concerns in society, and I think it's up to those of us who care about this and worry about this to make perhaps better efforts, maybe through the media, maybe through education, whatever, to try to have better conversations with people about more effective criminal justice processes so that people aren't clamouring for this ultimate penalty. And I think that's where the second part of the question around deterrence and public opinion comes in, because we know around the world whenever we interview elites involved in criminal processes or elites involved in politics or beyond in civil society, that the justifications for retention and indeed sometimes expansion of the death penalty are around the 2 points, deterrence and public opinion. This is why people think it's worth having the death penalty. So I'm doing some work in Indonesia at the moment, and everyone we speak to say these two things. It's about deterrence, it's about public opinion. And once you get a heinous crime like the rape or a sexual assault of children, then these things become persuasive to people. And but what we also know from rigorous public opinion surveys is that when you ask people, are you in favour of the death penalty, often they'll say yes, and you get sort of a 60-70% of the population will say, yes, I'm in favour of the death penalty. If you then explain to them how the death penalty works in practice, the failure of due process to protect defendants' basic rights, and the fact that that exposes people to the risk of wrongful conviction, and others to the risk of wrongful acquittal, once you educate people about that, their support for the death penalty declines. And once you also explain to people that the rigorous academic research done on deterrence does not provide sufficient support for us to go around telling people it's a deterrent, there just isn't the evidence to support that view, then again you can start to dismantle these key rationales for retention. And once you do that, you dismantle the key rationales for expansion. You start looking at pretrial processes and you look at other mechanisms to protect children. Nobody wants to have children being raped in society. No one wants to have women being raped or men being raped. These are social problems in any country, in every country. And so it's about really having those public conversations where we engage with people and we say, well, look, there are alternative ways to think about this. Let's go back to the pre-trial processes. Let's go back to policing and effectiveness of that. But also let's look at education systems. Let's look at what's happening in families. Let's looking at social care resources, etc. It's a huge problem that affects, that is systemic across health, education and criminal justice. So I think that we have a duty, once we see that and once we understand the research and the limitations, to engage a bit more effectively so that people aren't just holding on to this idea of hanging somebody as punishment for these awful crimes.
So good.
Yeah, I think the challenge, and it's a very difficult challenge, is to somehow change the narrative around punishment and around more severe punishments. I mean, we have it in the UK, more people being sent to prison for longer sentences, building new prisons. But somehow we've got to change the narrative, because when you ask people, people do know the answer to this, and we found this in the research we've done. And when you ask people questions not about their preference for the death penalty, yes or no, but when you ask people about what they think about effective criminal justice policy, nobody ranks the death penalty very high. These are people that may say they support the death penalty in abstract, but when you ask the same people to, we've done it in loads of surveys, we give them a ranking question, and we say, what is the most effective policy? And Carolyn mentioned a few of them: better policing, better moral education, more executions, and we give them a list of 6 or 7 options. And invariably, in every single survey we've done, this is in 8 different countries all over the world, the death penalty, more executions, is ranked last. And very, very interestingly, we've just finishing, it's not published yet, a survey of elites in the Caribbean. And the elites also rank the death penalty last in terms of effective policy. So nobody really believes that the death penalty is going to solve the problem. And that's the real issue, is the problem exists, but it's about changing the narrative to really focus on what is the real solution for the problem. And why people don't want to change the narrative is because it's very difficult. The solution is difficult, it's complicated, and it's going to take a long time. And that's the real issue. And it's cheap and quick and easy to talk about the death penalty.
And if I may just direct you to excellent research by the Centre for Child and Law at the National Law School, Bangalore, and Huck on implementation of the POCSO. Very, very revealing research as to why that system isn't working has very little to do with the harshness of the punishment and the reality of sexual violence against children, that there is massive underreporting of it, first of all. Second, it's mostly by people who are known to the victim, either family or neighbor or friends or any other relatives. And in that context, to introduce a harsher punishment is only going to worsen the problem of underreporting. Right? So this whole idea that we're going to protect children by harsher punishment is rather, I don't think is going to work, or is not true. We might want to believe it, right? But I don't think. If it is only about, oh, we hate people who rape children and we want to send them a message, sure, I mean, that kind of retributive instinct the death penalty might serve, but let's not kid ourselves that it will end up protecting children more, because it's highly unlikely to protect children more, right? So, yeah, I mean, with that we come to the end of the question session. If I may just ask Neetika to just conclude the discussion with her observations on this.
Hi, good evening. My name is Neetika and I head the work on sentencing at Project 39A. And I would want to take this opportunity to thank our panelists for a very insightful conversation on the rarest of rare death penalty sentencing framework in India and the Commonwealth. But before I go on to do that, I wanted to make some comments on the discussion that we've had today. So I want to start off with the study that we've been doing of trial court judgments over a period of 16 years in the states of Maharashtra, Madhya Pradesh and Delhi, where we have found an impact of the incoherence that Anup spoke about in the Supreme Court around death penalty jurisprudence, the confusion, the impact that it has had on trial courts, where we've seen that Bachan Singh has almost become a crime-centric framework where there is no regard for mitigation. And what we've also found is that this idea of similar cases and similar outcomes that Anup mentioned in the beginning has become an alternative framework in that sense, which is being adopted by trial courts. What is also emerged as an alternative framework to getting into this very difficult exercise of weighing aggravating and mitigating circumstances is using penological justifications to impose the death sentence. And that takes me to the conversation on public opinion that we've had today, and also asking ourselves that why is it that we end up conflating public opinion for having death penalty for an offense on our statute books and when you're individually sentencing someone. So yes, while public opinion may have been in favor of Criminal Law Amendment Act 2018 and bringing in death penalty for child sexual abuse, and that may have its own set of problems in terms of how far away it is from the realities of child sexual abuse in India. What does it mean to use arguments around deterrence and retribution when you're individually sentencing someone? What does it mean for the discretion, the judicial discretion that judges have to decide between life and death, and should penological justifications become a substitute for that? Another thing, another comment that I wanted to make was on the aspect of terror offenses, and this was one of the things that came up in an opinion study that we did in 2017 with 60 former Supreme Court judges, particularly around the Law Commission and its exception to not abolish death penalty for terror offenses. Few judges made a very interesting argument of, you're giving terrorists what they want, this idea of martyrdom. So basically, when you talk about deterrence, that doesn't seem to be, it seems very disconnected when you talk of deterrence and then you talk of having death penalty for terror offenses, because this is what these people want. And I just wanted to sort of make this comment because we found it really interesting. Another thing that I want to add is that while Bachan Singh did not, as Anup pointed out in the beginning, while Bachan Singh did not offer doctrinal clarity on what is aggravating, what is mitigating. So like Dave sir said, that while the judgment is very complicated and complex, it does not really tell you what is aggravation, what is mitigation, what do you do with these factors. It just says you have to weigh them, but how much weight do you attach to these individual factors, or what does it really mean when Bachan Singh, specifically for mitigating factors, says that you have to give it a liberal and expansive construction? Does that mean that numerically you have to consider 15 mitigating factors and only 2 aggravating? Or does it mean that when you say that you have to consider poverty as a mitigating factor, the understanding of that has to be very expansive, which has to look at a person's life history? There's no clarity on that. And so while Bachan Singh did not answer these doctrinal questions, and which has led to a lot of confusion, what it did categorically warn against was the standardization of death-eligible offenses. So even this entire approach that the Supreme Court has taken of, almost a practical mandatory death penalty when it comes to certain kinds of crime was something that Bachan Singh had categorically warned against. And the last thing that I want to sort of draw your attention to is what we have seen in our cases that we do at Project 39A, this increasing trend of resorting to life without parole. And I do think that it is part of the larger problem and the larger doctrinal gap of conversation around sentencing and criminal law in India, and philosophical foundational questions like why do we punish, and why do we punish, and what it means to have punishment for an offense on our statute books, and then what does it mean for an individual judge to sentence them, and what become relevant factors? Are you saying that by sentencing a person charged with sexual offense to death, are you responding to the increasing crimes against women, and is that the judiciary's job? Now I want to individually thank all the panelists. Thank you, Senior Advocate Siddhartha Dave, for giving us an extremely sharp picture of what it's like to work, how challenging it is to work with the Rarest of Rare framework in the Supreme Court of India, and also telling us about how judge-centric the imposition is, which is something that resonates with what we found in our study Matters of Judgment. And I particularly found it very useful because I'm a legal researcher and I don't go to court very often. So, and I've thought about these things from a very academic perspective, so it was very, very useful. Thank you so much, sir. I also want to thank Saul for sharing the wealth of his experience of litigating death penalty cases in the Caribbean and African jurisdictions. And the Caribbean approach definitely has a lot to offer in terms of how we think about the Rarest of Rare framework in India, and also in sort of helping us practically restrict imposition of death sentences in courts. Thank you so much, Saul. I also want to take this opportunity to thank Carolyn for tying up the entire discussion with her comments on sentencing practices across different jurisdictions, especially the emphasis on public opinion, mental health, and bifurcation of trial. Carolyn has always been a great pillar of support and encouragement for us at Project 39A. Thank you, Carolyn. I also want to take this opportunity to thank each one of you for taking the time out to join us, and especially to those of you who to stand throughout the discussion. We apologize for that. And this event would not have been possible without the hard work and support of my colleagues Aishwarya, Preeti, and Anup, and also our administration team. Thank you, Nidhi, Sangeeta, Ashu, and Dharminder. We've arranged some high tea, so please join us. Thank you and good night.
Thank you.